Contemporaneous legal discourse is often paralyzed with substantive arguments that both oppose and favor a particular question of law from seemingly equally merited standpoints. Illegality is a podcast that delves into often conflicting but equally incontrovertible aspects of legal discussion and provides listeners the opportunity to know all schools of thought governing legal issues. From the Journal and Seminar Committee of Department of Law, University of Calcutta, and co-hosted by Atreya Chakraborty and Samriddha Sen.
Hello everyone, welcome to Illegality, the weekly podcast of the Journal and Seminar Committee of the Department of Law, University of Calcutta, co-hosted by Atreya Chakraborty and I, Samriddha Sen, where we delve into the merits of conflicting arguments in legal discourse. In today's episode, we discuss socialism's incompatibility with liberal constitutionalism and the rule of law, the binding nature of the International Court of Justice's recommendations or directions upon the Supreme Court of India, and the reignition of the debate surrounding the death penalty on account of the Nirbhaya case. It is reminded to all listeners that any and all opinion given of the course of this episode are solely our own. The first topic of discussion in the very first episode of our podcast is one which is essentially an unconventional food for thought, one that offers discussion on whether the imposition and inclusion of socialism within the constitutional scheme of things has denuded away constitutional check and balance limitations on government and the possibility of state action adhering to rule of law principles. Frederick Bastiat, in his book The Law, makes a few observations about the nature of law and government which would be pertinent to mention in this case. He says, "It is not true that the mission of the law is to regulate our conscience, our ideas, will, education, sentiments, exchanges, gifts, and enjoyments. Its mission is to prevent the rights of one from interfering with those of another in any one of those things. Law, because it has force for its necessary sanction, can only have the domain of force, which is justice." On the limits of legal coercion for the achievement of justice, he says, "The socialists say since the law organizes justice, why should it not organize labor, instruction, and religion? Why? Because it could not organize labor, instruction, and religion without disorganizing justice. For remember that law is force and that consequently the domain of the law cannot properly extend beyond the domain of force. When law and force keep a man within his bounds, they impose nothing upon him but a mere negation. They only oblige him to abstain from doing harm. They violate neither his personality, his liberty, nor his property. They only guard the personality, liberty, and property of others. They hold themselves on the defensive, that is, they defend the equal rights of all. They fulfill a mission whose harmlessness is evident, whose utility is palpable, and whose legitimacy is not to be disputed. It ought to be said that the aim of the law is to prevent injustice from reigning. In fact, it is not justice that has an existence of its own, but it is rather than injustice. The one results from the absence of the other. But when the law, through the medium of its necessary agent, which is force, imposes a form of labor, a method or a subject of instruction, a creed or a worship, etc., it is no longer negative, that is, it acts positively upon men. It substitutes the will of the legislator for their own will, the initiative of the legislator for their own initiative. They have no need to consult, to compare, or to foresee, for the law does all that for them. The intellect is for them a useless encumbrance. They cease to be men, they lose their personality, their liberty, and their property." As all of you may know, the word socialism was inserted via the 42nd Amendment to the Indian Constitution in 1976 by a parliament which operated under emergency. Notwithstanding the concerns of such an amendment lacking qualified legislative competency on account of usurpation of state legislative powers and dilution of principles of federalism and constitutional limitations, we will argue a more fundamental question as to whether the addition and goal of socialist principles had any negative effects on the Indian example of constitutional democracy. We will lay out several aspects of such a conflict and or incompatibility, such as dilution of fundamental rights, including right to property, executive or legislative supremacy over constitutionalism, its ensuing judicial conflicts, and the oxymoronic nature of constitutional amendments which further socialist agenda, which are not subject to a textualist interpretation of the original constitution. Concerning the legislative dilution of fundamental rights for advancing principles of socialism, A. Palkiwala described the entire amendment process as the systematic defiling and defacing of the Indian Constitution. Over the course of 30 years since the original constitution came into effect, fundamental rights were progressively chipped away in favor of seemingly unquestionably righteous socialist goals, while some credit such a fall of constitutionalism to the failures of the Indian judiciary to check overzealous executive and legislative branches who were bent on disrupting appropriate separation of power check and balances. which the judiciary could have done by vetoing unconstitutional measures arising out of executive-legislative collusion intended to subvert constitutional authority through the test of judicial review. In this podcast, we will try to balance between judicial and legislative or executive developments to the best of our abilities. The threat of negation of fundamental rights in the impending wave of majoritarian socialism was first experienced with Nehru's creation of the Planning Commission. While the Planning Commission was not in and itself a threat to fundamental rights, the legislations which were passed subsequently to the creation of the Planning Commission to facilitate its goal to plan the entire country's economic destiny gradually denuded away constitutional liberties, and we explain how. We have attached a table to our transcript which essentially lays down the socialist policies with corroborated fundamental rights. So, for example, the table itself lays down that if there is one socialist policy and we correspond with a socialist, which is a fundamental right which has been denuded away along with the constitutional amendment. For example, the table has three sections. One is the implemented socialist policy, the other is fundamental rights, and the third is constitutional amendment which introduces socialist policy. For example, for centralization of industry, the essential structure of constitutionalism, which is federalism, cooperative federalism, that's no longer a thing, but yet it was taken away by the 7th Amendment. Similarly, for example, for price control, which essentially restricted the right to any occupation, trade or business, which was brought about the 3rd Amendment. Similarly, land distribution, which took away right to equality and right to private property, is brought about by the 1st Amendment. Similarly, the political reorganization and economic reorganization brought during the emergency years under the Indira Gandhi regime, which took away separation of powers, judicial review, 9th Schedule, 31B, the 42nd Amendment. Similarly, 25th, bank nationalization, again, right to private property and so forth. The table is pretty useful if you wish to completely understand how gradually they were chipped away. Moving on, in a sense, socialism advocates state or public ownership of the means of production. Although it may prima facie appear noble on account of its apparent public welfare objective, there are some technical economic aspects that we need to pay heed to. While theoretically, Austrian economist Ludwig von Mises has argued that without private property, there can be no exchange of the means of production, be it consenting or forceful, and in the absence of market prices, rational allocation of resources would be impossible, Austrian-British economist Friedrich Hayek argues a more technical aspect of state control of the means of production invariably leading to centralized planning, which is that central planners would always need the most accurate information needed to plan rationally at the central or federal level, and since the economy is unable to provide accurate information, central planners, at the risk of planning irrationally, which inadvertently leading to severe economic consequences, perpetually face an information crisis which is known as the Hayekian information model. Owing to the impossibility of rational economic decisions because of the information problem, Hayek demonstrates that the institutions that will emerge from centralized planning structures would fail to achieve the desired economic result. Hayek's information problem also demonstrates how centralized economic planning is fundamentally opposed to the rule of law, and we explained how. The principal tenets of constitutionally espoused rule of law is that a statute, regulation or directive is precise and detailed in terms of its regulatory ambit and provenance and is compatible with existing constitutional limitations, is in conformity with constitutional principles of equality, that is equality before the law and equal status of the law, without any apparent arbitrariness, and this is the operative part, and is disclosed beforehand to the public before being in effect. Hayek's information problem indicates that due to such impossibility of rational economic decision, central planners are endowed with unlimited discretion to execute their economic plan. Such discretion is therefore completely antithetical to the foundation of rule of law, thereby making centralized economic planning incompatible also. The first direct substantive threat faced by fundamental rights, the first direct meaning that this has the most value in terms of understanding how the history of fundamental rights emerged within political discourse, was under the Indira Gandhi regime. At the altar of populist politics, which eventually led to the breakup of the traditional political umbrella known as the Congress, that is the Nehruvian idea of Congress, Indira Gandhi separated herself from an economically moderate syndicalists. During Indira Gandhi's breakup, the syndicalists were essentially economic moderates, that is, they supported a limited state control, limited degree of privatization, to that extent that credit flow could happen within the economy. While Indira Gandhi broke off and created the far-left requisitionists, this was essentially a move to make her politically palatable because her decision rested on the then socialist populism which was resonating among the electorate. While the syndicalists subsequently broke off to form the Congress Originalists to the CEO, Indira Gandhi, by projecting herself as the, quote, real socialist, launched the 10-point program in 1997, which detailed policies what she called the commanding heights of the economy. This included rural housing, land reforms, urban land ceiling, exacting government control over scheduled resources in designated economic zones, nationalization of banks and insurance, essentially all the policies laid out in the 4th and 5th five-year plans, in addition to abolishing privy purses. Before the government could launch this 10-point program, the eminent domain authority of the state, which we discussed subsequently below under the right to property, and the amending authority of parliament was challenged in the Supreme Court in Golaknath versus State of Punjab, wherein the constitutional authority of the Punjab Land Tenures Act 1953 was questioned on the ground of it depriving the individual's right to property. In deciding the extent of Parliament's competency to amend the Constitution, the 11-judge bench of the Supreme Court, by majority opinion, held that Parliament cannot amend the Constitution so as to abridge fundamental rights, while refusing to retrospectively apply its dictum. To put it otherwise, and this is where the oxymoronic nature of constitutional amendments who have socialistic agendas come in, that is, to put it otherwise, constitutional amendments cannot give effect to unconstitutional laws. As always, to circumvent this judicial problem, the Indira Gandhi regime introduced the 24th and 25th Amendments to the Constitution. Particularly, the 24th Amendment Act of 1971 argued in its object and reasons that since the Golaknath case by a narrow majority overturned the pre-Golaknath jurisprudence which supported Parliament's competency to amend all parts of the Constitution, including Part 3 thereof, a law was needed which conclusively settles the finality of Parliament's absolute authority to amend the Constitution. The 24th Amendment, read together with the 25th Amendment, gave Parliament unchecked authority to amend the Constitution through Article 368 and eliminate any restrictions posed by fundamental rights and judicial review. Fortunately, this gaping constitutional hole was seemingly filled with Keshavananda Bharati, however, not in entirety. The said judgment did not explicitly and specifically bar parliamentary amendment of fundamental rights as long as they conform to the basic structure doctrine. Now, what is the basic structure doctrine? There is debate around it surrounding what it essentially stands. Perhaps, and with that concern in mind, perhaps with the same level of scrutiny, concern is apparent considering the prime test of conformity with the basic structure doctrine is left to non-objective and unempirical standards of judicial review. Moving on to the right to property, Adam Smith's prescient explanation of the origin and intent of the constitutional separation of power scheme comes to mind. In his book, The Wealth of Nations, he says, the separation of the judicial from the executive power seems originally to have arisen from the increasing business of the society in consequence of its increasing improvement. The administration of justice became so laborious and so complicated a duty as to require the individual attention of the person to whom it was entrusted. When the judicial is united to the executive power, it is scarce possible that justice should not frequently be sacrificed to what is vulgarly called politics. The person entrusted with the great interests of the state may, even without any corrupt views, sometimes imagine it necessary to sacrifice to those interests the right of a private man. Two explanations emerge from this quote. One being that the ongoing performance of administration and adjudication lead to specialization of these tasks, and the other being concentration of power in one branch of government results in violation of rights. There is now established academic literature to support the separation of power framework, social welfare utility, and it building strong governments and secure societies. The nature of property rights to be enshrined in the Constitution was a contentious issue in the Constituent Assembly debates. While framing such property rights, the Assembly had a clear reference model in the Fifth Amendment to the United States Constitution, the operative part being, nor shall any person be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Strikingly similar to the debates on the proposed inclusion of the phrase due process in a few drafts of Article 21, the debates surrounding property rights were also mired with concerns of Constituent Assembly members surrounding the textual existence of a due process safeguard for property rights. Now, what exactly does due process signify? As regards to both Article 21 and property rights, due process is the requirement of procedural fairness by placing restrictions on the operation of state authority having the possibility to deprive an individual of rights legally owed, in contrast to substantive due process, which goes to the root, object, nature, and statutory language of a law. Most of the concerns regarding due process in the Constituent Assembly was regarding the possibility of excessive judicial encroachment on administrative and public policy actions of government, because many Constituent Assembly members deriving their experience from British courts were skeptical of creating an independent judiciary with vast authority who could easily oppose the will of the people. While some voices talked of judicial overburden because most litigations in the United States are concerning due process, most oppositions were concerning due process's inherent obstruction of legislative effectuation of land reforms. Ultimately, bowing down to such voices, the draft article on property rights was removed of any connection between due process and right to property, further bolstered by the removal of just from the clause which guaranteed just compensation for acquisition of property for public purposes. Although this resulted in creating a right to property under Article 19(1)(f) of the Constitution, the same can be deprived under Article 31. As existed at origin, the article said no one could be deprived of their property except by law. The law must set a compensation or principles on which such compensation is paid. Property acquisition laws must get assent of the President. Police powers were provided in relation to property, and property legislation which was not subject to any subsequent judicial questioning on compensation was to be legislated in a stipulated time frame. However, over the next 30 years, the right to property was gradually chipped away, which eventually led to the 44th Constitutional Amendment at 1978, deleting Articles 91(f) and 31 from the Constitution. In this part of our discussion, I try to draw a concise timeline as to how it happened. Through the first 5-year plan, which called for land reforms and industrial development, the ruling Congress administration reflected the growing political impulse which favored to eliminate, preferably without compensation, zamindars, rural intermediaries who, under colonial rule, had gained rights over vast tracts of land in many parts of the country, and put into effect a socialist industrial policy that gave the state a major role in controlling both through the planning process and a mandate to take over concerns in the public interest and public industry. Such moves were challenged in courts under the original takings clause in Article 31 of the Constitution, which read, "No person shall be deprived of property without due process of law, and no property shall be taken possession of or acquired for public purposes under any law authorizing the taking of such possession or such acquisition, unless the law provides for compensation." One of the many state land reform laws which were challenged in this period was the Bihar Management of Estates and Tenures Act 1949, which assessed the compensation payable to the owner of property acquired at 20 times the assessment for a poor owner and at 3 times the assessment for a rich owner. In Kamleshwar Singh versus Province of Bihar, one of the first and indeed a landmark case on property rights, the Allahabad High Court, then having jurisdiction of the Province of Bihar, which included the region where modern Uttar Pradesh exists, held that the Bihar Management of Estates and Tenures Act 1949 was ultra vires the Constitution, holding that in addition to violations of Article 19(1)(f) and 31, it also violated Article 14 by discriminating richer zamindars from equal compensation and thereby struck it down. Similarly, the Bombay High Court received a case wherein mill owners had been deprived from the right to property as their establishments were taken over by government without any compensation. Considering the pervasive scale of land reforms that the government envisaged, it was impossible for it to pay fair compensation in every case of land distribution or property acquisition. Nehru defended the government's motive in the debating chambers of parliament by calling their socialistic policies as which represent the dynamic movement towards a certain objective and demeaning fundamental rights as something which represents something static, that is to preserve certain rights. And yet once again, to bypass the judicial onslaught posed by the then property rights jurisprudence, the Provisional Parliament of 1951 passed the first Constitutional Amendment Act of 1951, by which Articles 31A, 31B, and the 9th Schedule were added to the Constitution. Article 31A, in a sense, permitted the legislation of laws to acquire estates, a term used to cover the properties of zamindars and other categories of revenue farmers, the taking over of property by the state for a limited period either in the public interest or to secure the proper management of the property, amalgamate properties and extinguish or modify the rights of managers, managing agents, directors, stockholders, etc., and those who have licenses or agreements to search the grounds for mineral and oil. Such laws, as per this article, cannot be declared void on grounds that they are inconsistent with Articles 19, 31, and 14. Article 31B protected the various land reform laws, as we talked about, which enacted by both the centre and the states, by stating that none of these laws, which were to be listed in the 9th Schedule specifically, can become void on the ground that they violated any fundamental right. The First Amendment Act effectively diluted the eminent domain clause of the Constitution and the right to property so as to enable first 5-year plan policies. In a sense, it divested courts of any jurisdiction to challenge any preferred land reform legislation which is part of the 9th schedule, thereby effectively depriving any aggrieved individual to have any locus standi to approach any court of law for any remedy that would have been deemed appropriate as per law. However, it would appear that high courts across the country were unwilling to properly enforce land acquisitions without compensation resulting from acts operational exclusively within the 9th schedule. For example, in state of West Bengal versus Bela Banerjee, the validity of the West Bengal Land Development and Planning Act 1948 was challenged on the ground that it provided for acquisition of land after payment of compensation which did not exceed the market value of the land as computed on December 31st, 1946. The state argued that as per Article 31.2, which was read along with Entry 42 of List 3, the Constitution, it gave full discretion to the legislature in determining the measure of compensation, essentially making an argument also that the legislature has the right to make laws on property and thereby determining the stipulated compensation. The Supreme Court reasoned that while the legislature had the discretion to lay down principles on the basis of which the government paid compensation for appropriated property, such principles must ensure that the compensation is a just equivalent to what the owner has been deprived of, and that the content of such principles be adjudicated by the court. Once again, to eliminate any judicial obstacles, the Parliament passed the Constitution 4th Amendment Act of 1955. In this amendment, any major changes in the Constitution were centered on Article 31. In particular, Clause 2 of the article and a new Clause 2A was added to the article. Article 31.2, as it originally stood prior to the 4th Amendment Act, was that no property, movable or immovable, including any interest in or in any company owing any commercial or industrial undertaking, shall be taken possession of or acquired for public purposes under any law authorizing the taking of such property or such acquisition unless the law provides for compensation for the property taken compensation of or acquired and either fixes the amount of compensation or specifies the principles on which and the manner in which the compensation is to be determined. After the 4th Amendment, sadly, it read, no property shall be compulsorily acquired or requisitioned save for a public purpose and save by authority of law, which provides for compensation for the property so acquired or requisitioned, and either fixes the amount of the compensation or specifies the principle on which and the manner in which the compensation is to be determined and given. No such law shall be called in question in any court on the ground that the compensation by that law is not adequate. While the original Constitution prevented arbitrary takeover or control of management of private firms, the 4th Amendment to the Indian Constitution created a pathway for such rapid acquisition by eliminating scope of any judicial scrutiny. Article 31.2a of the 4th Amendment Act stated, no such law which transfers ownership or possession of property to the state or a corporation shall be called in question in any court on the ground that the compensation provided by the law is not adequate. Following a Supreme Court judgment in Dwarkadas Srinivas versus Sholapur Spinning and Weaving Company Limited, all references of which is given in the transcript, which you will find on the podcast medium page. In this case, the court held that the stockholders of a company which had been taken over by management under police powers, stipulated Article 31A, had to be paid compensation. A clarification was subsequently issued as a result of this judgment for Article 31.2a, which said that if property were not transferred to the state under a law, then it should not be deemed to have been a compulsory acquisition, even though there may have been deprivation of property. Adopting a strategy now all too familiar with us and similar to the First and Fourth Amendments, Parliament passed the Seventh Amendment after the Supreme Court's case in Karimbil Kunhikuman versus the State of Kerala. Apologies for the pronunciation. In this case, the court held that taking of lands under the Kerala Agrarian Reforms Act of 1961 was unconstitutional as per Article 14 because a smaller compensation was paid for larger tracts than for smaller holdings. Therefore, by logic, itself violating the basic tenets of Article 14. The Seventh Amendment was essentially enacted subsequent to this judgment just to remove certain land reform legislations, including the impugned Kerala Agrarian Reforms Act of 1961, from judicial review by adding all of these statutes within the purview of the 9th schedule, therefore effectively adding them. Two more amendments are crucial to discuss in this case when dealing with socialist policies, effects on property rights. These are the 25th and the 44th Amendment. Contrary to what you might have expected, and apologies to that extent, I will not be discussing the 42nd Amendment, which added this phrase socialism in the preamble of the Constitution, as well as other effects of socialism on Indian constitutionalism, the various aspects of it, because there is much here to discuss, but I cannot because of shortage of time. Rest assured, if we receive positive feedback on this episode, we may take it up on a future notice. The 25th Amendment was essentially introduced as a hasty move against judicial interference in socialist policies. In addition to the Golaknath case, as discussed, the case of Vajravelu Mudlidhar versus Special Deputy Collector, again apologies for the pronunciation, had profound impacts on a government riding on a socialist streak. In this case, the Acquisition Madras Amendment Act of 1961 for the purpose of building houses, and this move was challenged under Articles 31 and 14. The stance of the Supreme Court in interpreting Article 31(2) was effectively in consonance with the decision given by the Supreme Court of the Bella Banerjee case, as discussed earlier. In this case, the majority order accepted Justice Subbarau's view that both before and after the amendment to Article 31(2), there is a right to compensation, and by giving illusory compensation, the constitutional guarantee to provide compensation for an acquisition was not complied with. It was also stated that the legislature is not the final authority on compensation. To get a flavor of the judgment, the following quotation is illustrative. The Constitution guarantees a right to compensation, an equivalent in money of the property compulsorily acquired. That is the basic. The law must therefore provide compensation, which is supporting the basic guarantee, and for determining compensation, relevant principles must be specified. If the principles are not relevant, the ultimate value determined is not compensation. This judgment, along with Golaknath, came at a time when the government was all invested in nationalization and other socialist endeavors. On the basis of record available, it was apparent the supposed political and intellectual currents at the time were inclined in overcoming fundamental rights to give directive principles of state policies precedence over fundamental rights, keeping courts out of acquisition and compensation matters, and to take property effectively out of the domain of the protection of fundamental rights. A protection which we all know is tenuous at best. The 24th Amendment authorized Parliament to amend any part of the Constitution and mandated that the President shall give his assent to any constitutional amendment presented before him. The 25th Amendment, on the other hand, suppressed the legacy of all judgments that had raised issues of paying just compensation by replacing the term compensation in Article 31, Clause 2 with amount, and barred courts from questioning this amount on grounds that it was inadequate or paid in terms other than cash. No kidding there. This amendment also inserted a new article, which is Article 31C, which said that no law declaring its purpose to be fulfilling the directive principles could be challenged in any court of law that it did not do so. Moving on to the 44th Amendment, this is how would I put it? It's a bit contrarian amendment because it does some benefits and it poses some challenges on the other hand. Let me brief it up for you. Now, while the 44th Amendment, while it reversed several emergency legal loopholes which gave excess authority to the Indira Gandhi regime and retained Article 31C and fundamental rights which expressly protected the individual from excesses of the state, it also deleted the right to private property and removed all restrictions on the power of eminent domain. As an empty gesture, the amendment kept the now diluted right to property as Article 300 capital A, which read, "No person shall be deprived of his property save by authority of law." The law minister at the time, Shanti Bhushan, justified the removal of property as a fundamental right by saying in Parliament the vast majority of Indians did not own extensive property, to equate the right to property to the more important rights, which had resulted in its curbing to protect the other fundamental rights. The present stance of the Supreme Court in regard to property rights, which is the post-44th Amendment jurisprudence, can be found in Jilubhai Nanbhai Khachar versus the state of Gujarat, once again apologies for pronunciation, in which the apex court held that the state had the right to take land of revenue farmers for the purpose of mining under Article 300 capital A without entertaining any discussion on adequacy of compensation, while unequivocally holding that the right to property is not a basic structure feature of the present constitution. The irony behind all this was that despite the neo-socialistic cries of a Nehruvian politics, within the first 30 years of independence, there was no attention to instituting social provisions akin to European social democracies, thereby propagating many neo-socialistic perspectives that over this period it was flawed nationalism rather than actual egalitarianism or redistributionism which dominated the then contemporary economic policy. That is all I'm able to discuss for today's episode on this subject. There is much more to it, I assure you, than which I'm unable to address today because of time constraints. In addition to all the references provided in our transcript, which I'm sure you'll find in our Medium podcast page, please feel free to reach out to the committee for any queries, scholarship readings, or suggestions. Now, before we proceed on to the main debate surrounding the use of death penalty for heinous offences, as in the case of Nirbhaya, which will be addressed by my co-host Atreya, upon the request from one of our classmates, we would first address a more primitive question concerning the coercive force of international law, one that has significant ramifications for real and jurisprudential sovereignty, and that question is whether the Indian Supreme Court is bound by the recommendations or directions issued by the International Court of Justice at The Hague. This is a question that essentially concerns a jurisdictional issue at best and a legal sovereignty issue at most. Perhaps the fallacy of international law is best presented by noted English legal theorist John Austin in his book Province of Jurisprudence Determined. In volume 1 of his book, he says, the so-called law of nations consists of opinions or sentiments current among nations generally. It therefore is not law properly so called. But one supreme government may doubtless command another to forbear from a kind of conduct which the law of nations condemns, and though it is fashioned upon law which is law improperly so called, this command is a law in the proper significance of the term. Speaking precisely, the command is a rule of positive morality set by a determinate author, for as no supreme government is in a state of subjection to another, the government commanding does not command in its character of political superior. If the government receiving the command were in a state of subjection to the other, the command, though fashioned on the law of nations, would amount to positive law. Austin therefore considers international law as a misnomer, regarding it as more ethical than legal in nature for lack of sovereign sanction. There are two notable elements of Austin's critique of international law. The first and foremost is legal positivism, and the second is international law's frustration of Austin's theory of legal command. As regards to legal positivism, Austin holds that the existence of the law depends on social factors and not simply on its merits. Austin formulates legal positivism as the existence of law is one thing, its merit and demerit another. Whether it be or be not is one inquiry, whether it be or be not conformable to an assumed standard is a different inquiry. Society, says Mr. Austin, formed by the intercourse of independent political societies, is the province of international law or of the law obtaining between nations. For adopting a current expression, international law or the law obtaining between nations is conversant about the conduct of independent political societies considered as entire communities. Speaking with greater precision, international law or the law obtaining between nations regards the conduct of sovereigns considered as related to one another, and hence it inevitably follows that the law obtaining between nations is not positive law, for every positive law is said by a given sovereign to a person or persons in a state of subjection to its author. As I have already intimated, the law obtaining between nations is law improperly so called set by general opinion. The duties which it imposes are enforced by moral sanction, by fear on part of nations or on the part of sovereigns, by provoking general hostility and incurring its general evils in case they should violate maxims generally received and respected. This brings us to Austin's theory of legal command. There are several elements to Austin's argument against the legality of international law, which I will discuss now. International law is considered equal among equal sovereign nations, meaning it does not have the coercive sanction of a supreme sovereign which commands obedience through a monopolized and unilateral usage of force. Now, what does Austin mean by sanction which stems from the command of the sovereign? Austin considers the sanction of the sovereign as an instrument by which the rule of law is universally applied, which in the most strict sense demands and compels obedience to the subject matter of the sanction. For sanction is not an end in itself, it is most a means to an end, which is namely obedience to the command of the sovereign and the rule of law. Therein exists the fundamental difference between municipal law or domestic law and international law. While the former is considered binding on a domestic community or society, international law, primarily comprising of usages and customs, regulate foreign relations between states. For example, W.E. Hall calls international law to be binding upon states only to the extent of their foreign relations. Conversely, international law can be considered as law in the strict sense of the term if a nation binds itself by a treaty, positive agreement, or a violation of rights under the treaty which would attract the command of the injured state to the state committing the infraction before an international tribunal. While the argument is not sound considering the lack of any mechanism to command obedience to international agreements or laws other than merely persuasive economic sanctions, it reflects that should states at an international level accept and enforce the customs and usages that are considered as principal tenets of international law, it would add an element of legal positivism to the effect of the said law. Coming to whether the Indian Supreme Court is bound by the recommendations or directions of the International Court of Justice, on March 16th, it was reported that the Nirbhaya convicts, then slated for execution on 20th of March at 5:30 a.m., wrote a letter seeking urgent hearing before the International Court of Justice to stay their quote unlawful execution on grounds of seriously doubtful improprieties occurring in procedural and investigative trial processes. The International Court of Justice's jurisdiction is essentially twofold. It decides disputes of a legal nature submitted to it by states in accordance with international law, which is its jurisdiction in contentious cases, and renders advisory opinions sought by UN organs, specialized agencies, or organizations authorized to make such a request, which is its advisory jurisdiction. Article 36, Para 2 of the ICJ statute states that the states parties to the statute of the court may at any time declare that they recognize as compulsory ipso facto and without special agreement in relation to any other state accepting the same obligation the jurisdiction of the court. Each state which has recognized the compulsory jurisdiction of the court has in principle the right to bring any one or more other states which have accepted the same obligation before the court by filing an application instituting proceedings with the court. Conversely, it undertakes to appear before the court should proceedings be instituted against it by one or more other such states. As regards to India's declaration dated 27 December 2019, recognizing the jurisdiction of the ICJ as compulsory, the said jurisdiction is barred in cases falling essentially under the domestic jurisdiction of India, among others. Therefore, not only does the ICJ's jurisdiction exist at the request of a state filing against one or more states, the entire aspect of criminal justice for crimes committed by Indian citizens on Indian soil falling exclusively within the jurisdictional competence of the Indian courts divests the convicts of any local standi to approach the ICJ. As regards to enforcement of ICJ decisions, Article 94(1) of the UN Charter reads as each member of the United Nations undertakes to comply with the decision of the International Court of Justice in any case to which it is a party, while Article 94(2) lays down that if any party to a case fails to perform the obligations incumbent upon it under a judgment rendered by the court, the other party may have recourse to the Security Council, which may, if it deems necessary, make recommendations to decide upon measures to be taken to give effect to the judgment. While vesting the authority to enforce the decisions of the International Court of Justice with the UN Security Council or the UNSC, the presence of the word may within the statutory wording indicates that either the Security Council can choose to not enforce an ICJ decision, or a resolution to enforce an ICJ decision is subject to the veto power of any UNSC permanent member state. Moreover, since it is also evident that the UNSC may not be the only body with the vested authority to enforce ICJ decisions, a party alleging the non-compliance of an ICJ order or decision may file a complaint before the UN General Assembly under Articles 10, 11, 14, 22 and 35 of the UN Charter vis-à-vis Resolution 377, also known as the Uniting for Peace Resolution. Thus, the Indian Supreme Court is not bound to adhere to an ICJ recommendation or direction, as criminal justice is an established aspect of jurisdictional sovereignty, and unless the Indian government was a party to an ICJ matter which dealt with that question with a question of law which was identical to a matter pending before the Supreme Court, no question regarding the same arises.
The subject matter of death penalty has been at the center of sustained legal discourse and deliberation all over the world. Even though the nature of arguments both advancing and assailing the retention of such form of punishment has not undergone a substantial amount of change, a fresh reconsideration of these arguments in this first episode of illegality seems warranted, particularly in light of the Indian perspective and the reignition of the debate concerning death penalty subsequent to the execution of Nirbhaya case convicts on the 20th of March 2020. Death penalty undoubtedly leads to the deprivation of life and personal liberty of an individual, albeit according to procedure established by law. Therefore, it may be prudent to analyze briefly the judicial interpretation of the phrase procedure established by law in light of two landmark decisions of the Supreme Court of India. In the initial stages of the post-independence era, the judgment delivered by the Supreme Court in the matter of A.K. Gopalan versus State of Madras gave due recognition to the precept that the sole issue which could be subjected to judicial review was whether the law authorizing the deprivation of life or personal liberty has been duly enacted by the legislature or not. In A.K. Gopalan, the apex court had deliberated upon the meaning of the expression procedure established by law at great length while determining the constitutionality of the provisions of the Preventive Detention Act of 1950. The reason behind apex court's reluctance to strike down arbitrary restraints imposed by the provisions of the said act could arguably be narrowed down to paragraph 23 of the said judgment, the relevant portions of which may be read out as follows. The phrase procedure established by law seems to be borrowed from Article 31 of the Japanese Constitution. Moreover, the word due in the expression due process of law in the American Constitution is interpreted to mean just, according to the opinion of the Supreme Court of the United States. That word imparts jurisdiction to the courts to pronounce what is due from otherwise according to law. The deliberate omission of the word due from Article 21 lends strength to the contention that the justiciable aspect of law, that is to consider whether it is reasonable or not by the court, does not form a part of the Indian Constitution. In the judgment so delivered, procedure established by law was interpreted literally, that is, judging the reasonability of procedure was kept out of the scope of judicial review. Subsequently, in the aftermath of the emergency in 1975, a new trend of recognition of human rights set foot in the Indian jurisprudence. Around the same time, the Supreme Court in the matter of Maneka Gandhi versus Union of India had inserted the concept of just and reasonable procedure in the interpretation of Article 21. Such scenario inevitably raised questions of the constitutionality of death penalty. The first challenge to the constitutionality of death penalty in India came in the year 1973 in the case of Jagmohan Singh versus State of UP. Even though other grounds of challenge were also instituted by the petitioners, presently it shall be prudent to concentrate on the contention that the discretion vested in judges in deciding the imposition of death sentence was uncontrolled, unguided, and therefore violated Article 14. Dealing with the question of discretion and violation of Article 14, the Supreme Court had made the following observations in paragraphs 26 and 27 respectively. In para 26, the Supreme Court had stated that the impossibility of laying down standards is at the very core of the criminal law as administered in India, which invests the judges with a very wide discretion in the matter of fixing the degree of punishment. That discretion in the matter of sentences, as already pointed out, is liable to be corrected by superior courts. The exercise of judicial discretion on well-recognized principles is, in the final analysis, the safest possible safeguard for the accused. Such observation of the Supreme Court was based on the premise that in England, a royal commission appointed with the mandate of recommending straightforward principles for determining the circumstances warranting death penalty had ultimately failed to lay down such standards, citing that no amount of experience would be enough to aid in fixing an exhaustive set of rules in respect of the award of death sentence. In paragraph 27, the Supreme Court had stated that if the law has given to the judge a wide discretion in the matter of sentence to be exercised by him after balancing all the aggravating and mitigating circumstances of the crime, it will be impossible to say that there would be at all any discrimination, since facts and circumstances of one case can hardly be the same as the facts and circumstances of another. Undoubtedly, it is not possible to recommend a uniform set of principles governing judicial discretion in matters such as imposition of punishment. Discretion with respect to the procedure of sentencing is presently allied with the virtue of greater restraint and a more liberal consideration of the mitigating circumstances of the crime due to the introduction of the requirement of sentencing hearing post 1973. This in effect serves as a positive impediment against arbitrary exercise of discretion in the imposition of death penalty. By a perusal of the aforequoted excerpts of the judgment, one can most certainly infer that the Supreme Court had, in fact, accepted that the judges were vested with a wide discretion in deciding the degree of punishment. While the vesting of such discretion may be justified in accordance with the reasoning provided by the apex court, such reasoning does not in its entirety quell the fear of irregular exercise of such discretion and dissimilarity in sentencing in similar circumstances. Reflecting on the perils of absence of any uniform legislative policy guiding the exercise of discretion by the courts in awarding death penalty, the Supreme Court in the matter of Ediga Annamma versus State of Andhra Pradesh at paragraph 26 had made the following observation. A legal policy on life or death cannot be left for ad hoc mood or individual predilection, and so we have sought to objectify to the extent possible, abandoning retributive ruthlessness, amending the deterrent creed, and accenting the trend against the extreme and irrevocable penalty of putting out life. Furthermore, in the matter of Bachan Singh versus State of Punjab, Justice Bhagwati, in his dissenting judgment, had observed that in the context of the award of death penalty, Indian courts have demonstrated ample amount of uncertainty and arbitrariness, as there are innumerable cases bearing similar fact situations, but the award of sentence as to life imprisonment or death penalty varies in each of these cases. Moreover, he had held that since there are no guidelines prescribed in respect of imposition of death sentence, and the judges have unusually wide discretion in respect of the same, the vesting of such discretion can be viewed as unconstitutional on ground of violation of Article 14. Upon a bare reading of the above discussion, it may be stated that since there are no fixed guidelines in respect of imposition of death penalty, and the inability to lay down such guidelines is well settled, it may be wise to retreat from the imposition of death penalty, and it could be the only possible solution to the arbitrary exercise of discretion in the imposition of death penalty. In Bachan Singh, the majority of the bench upheld the constitutionality of death penalty and at the same time prescribed that death penalty should be imposed only in the rarest of the rare instances. The court had held that in order to prevent the arbitrary imposition of death penalty, determination of the aggravating and mitigating circumstances of the crime must be based on well-reasoned principles crystallized by judicial decisions for the purpose of acquiring guidance as to what may be considered as aggravating and mitigating circumstances, respectively. The court had further held that only if an analysis of the aggravating and mitigating circumstances brings to light exceptional reasons that warrant death, shall capital punishment be imposed. Thus, it cannot be doubted that the discretion exercised by the court in making a choice between capital punishment and life imprisonment should always be tempered with humane concern and compassion. The extreme infrequency of imposition of death penalty bears testament to the caution and compassion with which the courts have proceeded in imposing the ultimate penalty upon a convict. At the same time, however, the experience of working off the rarest of the rare doctrine based on consideration of the mitigating and aggravating circumstances has often been fraught with concerns of arbitrariness and judicial inconsistency. In substantiation of the aforestated contention, it shall be prudent to place reliance upon the 262nd report of the Law Commission of India. In paragraph 5.2.1 of such report, the Law Commission had stated that Despite the court's optimism in Bachan Singh that its guidelines will minimize the risk of arbitrary imposition of death penalty, concerns that capital punishment is arbitrarily or freakishly imposed continue to haunt the death penalty jurisprudence in India. In the last decade itself, in cases like Alok Nath Datta versus State of West Bengal, Swami Shraddhananda versus State of Karnataka, Santosh Bariyar versus State of Maharashtra, Mohammad Farooq Abdul Ghaffur versus State of Maharashtra, the Supreme Court has acknowledged that the application of death penalty is subjective and arbitrary. At this juncture, it shall be necessary to point out that the Supreme Court, in paragraphs 34 to 41 of the judgment delivered in the matter of Sangeet and another versus State of Haryana, had noted 3 judgments delivered by itself, wherein the court's earlier dictum of considering aggravating and mitigating circumstances in Bachan Singh was not followed. Furthermore, for a better understanding of the ambivalence present in the appreciation of aggravating and mitigating circumstances of a crime, reliance may be placed on another excerpt from the 262nd report of the Law Commission of India. The said paragraph runs as follows. In Dhananjay Chatterjee versus State of West Bengal, the Supreme Court had imposed the death sentence on the offender for committing the rape and murder of an 18-year-old woman who lived in a building where he was a security guard. This case was noticed in Ramesh Bhai Chandu Bhai Rathod versus State of Gujarat, which, according to the court's own assessment, involved similar facts, except that the rape and murder in this case was that of a child. On reference to a larger bench, because the 2-judge bench could not agree on the sentence, the 3-judge bench of the court noted the similarity of facts to Dhananjay Chatterjee's case, but held that offender's age was only 28 years, which left open the possibility of reform, and hence imposed the life sentence. Therefore, in an admittedly similar fact situation, Ramesh Bhai Rathod was given the life imprisonment because he was 28 years old. On the other hand, Dhananjay Chatterjee, when executed in the year 2004, was only 27 years old. From the aforementioned excerpt, it may so appear that even though the factual matrix and the crime committed in both cases appear to be considerably similar, punishment was imposed differently. Irrespective of such prima facie similarity, it would be imprudent to assume that all factors which might have been capable of swaying a judicial mind of a human being in favor of or against choosing a particular mode of punishment were exactly the same in both cases, since there are numerous other circumstances justifying the passing of the lighter sentence, as there are countervailing circumstances of aggravation. We cannot possibly feed into a judicial computer all such situations, since they are astrological imponderables in an imperfect and undulating society. Death penalty has often been justified on the basis of its deterrent value. Deterrence aims to prevent individuals from offending by using the fear or threat of punishment. The assumption behind the deterrence theory is that all persons are rational individuals and they will commit a crime only if they perceive that the gain to be received from such criminal act will be far greater than the pain that they will suffer from its penal consequences. The belief is that the operation of deterrence is strengthened when the punishment is made as severe as death itself. No person in his or her right mind would commit an act which may result in the loss of one's life. In Trope versus Dulles, Justice Brennan, in emphasizing the deterrent value of punishment in general, has stated the following: rehabilitation is but one of the purposes of penal law. Among other purposes are deterrence of the wrongful act by the threat of punishment and insulation of society from dangerous individuals, either by imprisonment or execution. Subsequently, in Furman versus Georgia, Justice Stewart took the view that in certain cases the nature of the crime committed is so atrocious that society's interest in deterrence far outweighs the considerations of reform and rehabilitation. Reflecting on the deterrent value of capital punishment, the Supreme Court of India, speaking through V.R. Krishna Iyer, had held that when the disease is social, deterrence through court sentence must, per force, operate through the individual culprit coming up before the court. Social justice has many facets, and judges have a sensitive, secular, and civilizing role in suppressing grievous injustice to humanist values by inflicting condign punishment on dangerous deviants. Furthermore, in the matter of Ediga and Amma, it was held that deterrence through the threat of death may still be an effective measure in preventing future occurrences of murderous crimes. Apart from these, the Supreme Court has often used deterrence as a justification for imposing death penalty. For instance, while imposing the death sentence in the matter of Mahesh versus State of Madhya Pradesh, the court had noted that the common man understands and appreciates the language of deterrence more than the reformative jargon. In Jashuba Bharat Singh Gohil versus State of Gujarat, the court had held that the protection of society and deterring the criminal is the avowed object of law. In light of the aforementioned observations and decisions, it may be safe to state that for long, deterrence has been viewed as an essential element and objective of death penalty. Such view, however, is not free from criticism, as there is no concrete evidence suggesting that death penalty has an assured deterrent value, which in turn leads to the mitigation of heinous crimes. After many years of research and statistical analysis, a worldwide consensus has been reached that there is no evidence to suggest that death penalty has a deterrent value. Isaac Ehrlich, in his study published in 1975, suggested that there is a unique deterrent effect of executions on murders. Also, according to his research, statistically, one execution can save up to 8 lives. The Supreme Court of India had relied upon such study in Bachan Singh and had placed great value on such study. Subsequently, however, many flaws were discovered in Ehrlich's methodology and assumptions. A panel set up by the National Academy of Sciences in the United States of America, chaired by the Nobel laureate Lawrence Klein, for the purpose of reviewing Ehrlich's study, had reached a conclusion that the available studies provide no useful evidence on the deterrent effect of capital punishment. In another independent study, Donohue and Wolfers had stated that the existing evidence for deterrence is surprisingly fragile, and even small changes in the specifications yield dramatically different results. Our estimates suggest not just reasonable doubt about whether there is any deterrent effect of the death penalty, but profound uncertainty. We are pessimistic that existing data can resolve this uncertainty. The aforementioned criticisms with respect to the deterrent value of death penalty have also been supported by the United Nations, which has consistently held that there is no empirical data to suggest that death penalty has a deterrent value, especially in resolutions on the moratorium on the use of the death penalty of 2008, 2010, 2013 and 2015. However, here it is important to note that India is not a signatory to such resolutions. One might argue that the presence of the system of appeals and a legal provisioning for a separate hearing on deciding the extent of sentencing are reasonable safeguards against the possibility of miscarriage of justice. Moreover, formulation and application of the rarest of the rare case doctrine, having restricted the imposition of death penalty only a very few cases, the issue of miscarriage of justice is a myth. Such argument, however, falls flat upon a reading of the following excerpt from the 262nd report of the Law Commission of India. In just 3 cases, Bariyar, Sangeet and Khade, the court acknowledged error in 16 cases involving death sentence to 20 persons. 16 of these persons were sentenced to death in the period between 2000 to 2013, which implies that the Supreme Court has admitted error in imposing the death penalty on 16 persons out of the total 69 who were given the death penalty by the court in this time period. Therefore, there is an error rate of 23.2%. Such acknowledgement of error in the imposition of death penalty reverberates with the oft preferred argument of the abolitionists that since the criminal justice system comprises of human beings, the chances of miscarriage of justice will always be present. In his book Punishment and Culture, Philip Smith, in his inimitable style, had said, "Punishment is a deeply meaningful activity that still needs to be interpreted if it is to be understood." Similarly, the extent of legal discourse with respect to the subject of death penalty being very vast and expansive, a foolproof interpretation and by consequence thereof an immaculate understanding of the need, viability and effect of using death penalty as a mode of punishment cannot be derived only from the discussion held under the preceding subheadings. It is true that the aforestated discussion brings to light certain exigent criticisms against the use of death penalty. At the same time, however, one cannot simply turn a blind eye to the fact that death penalty as a mode of punishment has time and again passed the test of constitutionality. Therefore, it would be foolhardy to assume that in each of these instances wherein the constitutionality of such form of punishment has been upheld, the criticisms brought to light as a result of the aforestated discussion or otherwise have been outright ignored by the respective courts. The absence of a straitjacket formula requiring the imposition of the ultimate penalty upon all convicts of murder or other crimes punishable by death is ample proof of the reluctance of the courts to impose capital punishment, born out of the paramount importance of preserving the lives of such convicts, thereby giving them a chance at reformation. Moreover, each and every decree of death penalty issued bears a painful testimony to the growing cruelty in the minds of people, and under all circumstances is a very grave event. To conclude, I would like to put forward two questions. First, is it prudent to continue with a mode of punishment which is fraught with criticisms of arbitrariness and ineffectiveness? And second, in the absence of death penalty, what would be the appropriate form of punishment for those convicted of diabolical and unimaginable crimes that shake the collective conscience of the society, such as in the case of Nirbhaya, and thereafter show no semblance of remorse? Thank you.
Before we conclude, we would like to thank all members of the committee who have helped and supported us through this venture. If you enjoyed listening to our podcast, consider following us on twitter.com/CULawJSC and on Facebook at www.facebook.com/CULawJSC. The full transcript of this episode of the podcast can be accessed at its official Medium page at www.medium.com/il-legality-podcast. Thank you everybody, and please stay tuned for details in our next episode.